Prison lab. It has it on the
Sorry.
prison, oh, prison lab, there it is.
There you
Yes,
go. Counsel for Prison Lab, we're not on mute or anything.
no,
All right, before we'll come back to that matter. Prison Lab versus City of Detroit.
Good morning, Your Honor. Chris Long, P79930, on behalf of Prism Lab.
Calvert Bailey, P424,
What city?
P42409 on behalf of the city.
All right, thank you, Mr. Bailey. Good morning to the two of you. I have this set up for review. I know I did a scheduling order on this previously. So somebody update me regarding this matter.
Yes, Your Honor. Council is a little behind. We just need a little bit more time. They fell behind. They were on recess when this case was first settled, and they're just catching up.
All right. So that's where you are with this as well, Mr. Long. You're on the same page on this.
Yes, Your Honor.
All right. So the hardest question in the market, how much longer? Mr.
Probably-
Bailey, do you have any anticipation?
Probably about 3 weeks, Your Honor, 4 if you can stretch it.
All right. So what I'm going to do, if that's okay with the person, I'm going to go ahead and issue my order of conditional dismissal that becomes final if the settlement is released and approved and released. So that's typically the way that I do these. So I'm going to go ahead and issue that order. It seems that the resolution is imminent. What do you think, Mr. Bailey?
That is correct. It should be imminent, Your Honor, and we have no objection to that order.
Very well. And Mr. Long?
We have no objection either, Your Honor.
All right, you receive that from me in the next few days. It'll have a provision for automatic reinstatement should the agreement fall apart. But of course, once it's approved and funds are issued, then that conditional dismissal will become a final order of dismissal of prejudice. All right. Good day, gentlemen.
Thank you, Your Honor.
Thank you, Your Honor.
That calls case number 21-15020. This is strike that case number is 21-150-207. That's Community Financial Credit Union versus Vondre Washington. The matter is before the court on petition in order to show cause. Your appearance for Community Financial Credit Union, Avante Washington. All right, the court will recall that matter momentarily. All right, this is case number 21-64776. This is for Transportation Inc. Et al. Versus Michigan Automobile Insurance Placement Facility. Your appearance for Transport, please.
Good morning, Your Honor. Eric Noga, P83611, appearing on behalf of plaintiffs.
Thank you, Mr. Noga. Good morning to you. For defendant Michigan Placement, please.
Yes, Talithma Home, Your Honor, P number P789, sorry, 79890. But this matter was actually assigned to Nationwide, and so our office is now representing Nationwide as the defendant.
Yes, Your Honor. I believe
Right.
I believe a stipulated order was submitted to that effect to sub in Nationwide.
Right, and I'm seeing that now. there was someone standing in for me when this order came through, and I see that, that order has been entered, so, yeah, the court acknowledges that the, defendant in this matter is Nationwide Mutual Fire Insurance. All right, so, this has been going on for a bit here, so, I know there was some problems with getting, a witness in and so on and so forth, so somebody update me, tell me where things are.
Yeah, from my point of view, Your Honor, since this was just assigned to Nationwide, we just got some approval. I think we can, if Ms. Noga and I can get together, we can possibly resolve this matter.
All right, you want to take a moment in a breakout room at least to begin talking about this a little bit?
That would be
Sure.
perfect.
There you are, and Ms. Mahone, let's get you there as well. All right, there you go. And I'll
Thank you,
hand
Your
it
Honor.
down. Thank you. All right, the court calls case number 22-177-500. This is iHealth Pharmacy LLC versus City of Detroit. Looks like there is defendant number 2, Michigan Auto Insurance Placement Facility. The matter is set on for a motion, for hearing on a motion for summary disposition. Matter is also scheduled for general pretrial on today's date. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Jonathan Green on behalf of the plaintiff. My P number is 51461.
Thank you, Mr. Green. Good morning to you, sir. For the City of Detroit regarding this matter.
Thank you. Good morning, Your Honor. Joel Ashton, appearing for the City of Detroit, P number 47039. And for the record, I can state that the second defendant has been dismissed from the case.
That is correct.
All right. You anticipated my my question. All right, very well. And with that, it looks like I do have in front of me a motion for summary disposition. It looks like that related to Michigan Auto Insurance Placement Facility. Is there another motion regarding this matter?
Your Honor, that should be the city's motion for summary disposition on the 1-year back rule.
I'm looking. The assigned claims facility motion is jumping at me twice. And the city's motion is hidden. So let's take a little further look here.
The same thing happened to me this morning, Your Honor. So
All right, I do see defendant's motion for summary disposition regarding the 1 year back rule. Counsel, Ms. Green, did you file a response in that regard?
I did, Your Honor, July 8th.
Boy, let's see if we can be so lucky here. Not there. Just one moment. I got multiple folders here that kind of all. There it is. All right. And I do have both of the relevant and important documents in front of me. Mr. Ashton, go ahead on this simply complex issue, sir.
Thank you, Your Honor. We also filed a reply. Is that in your file?
Uh-oh. Let's do one more little search here. Just 1 second. Yes,
Very
that's
good.
it. I have that as well, Counsel.
Very good. Would you like me to proceed?
Yes, go ahead and proceed if you will at this time.
Thank you, Your Honor. Just very briefly, this is the defendant's motion for summary disposition on the 1-year back rule on this PIP case. The motion is based on the undisputed facts that the bills at issue were all incurred in November of 2020, but the plaintiff provider did not commence suit until January 2022, approximately 14 months later. Accordingly, it's our position that those bills should be barred by MCL 500.3145. The provider did file a response, but in its response ignored that as a provider, it steps into the shoes of the underlying patient, who in this case is Mr. Stromile, Stromile. We've attached to our motion the denial letter that was sent to Mr. Stromile's attorney, denying his specific claim for benefits in total in June of 2020. In their response, the plaintiff wants to attack the validity of that denial, but under the law, if that provider wanted to take issue with the denial, it was required to file suit within 1 year, which it did not. There's also reference in plaintiff's response that it seems to think that it has a right to discovery, or perhaps discovery should be conducted before this motion is performed. But that is also a false argument. Discovery is not required to determine the issues in this motion. Furthermore, I don't think that there would be a right to discovery in this case, since plaintiff did not file initial disclosures. There are references in plaintiff's response raising issues as to what may have happened with the underlying patient. In our initial disclosures, we actually attached a copy of the order dismissing Mr. Stromile's case. The denial of his claim pre-suit was based on his failure to cooperate, which was essential to determining whether or not there was coverage and priority on his PIP claim. And he then continued his lack of cooperation upon filing suit. And his case was eventually dismissed with prejudice based on his failure to cooperate in discovery, failure to appear for a facilitation, and then failure to appear for a settlement conference. Finally, Your Honor, even if plaintiff were to support a claim that the PIP claim was told, that argument would fail because the plaintiff also has a right or a duty to pursue its claim with diligence. And in this case, the facts are clear that the provider waited 14 months to file its own claim. And moreover, when it had an opportunity at an earlier time to intervene into the patient's lawsuit, failed to do so, but instead waited and then filed this untimely lawsuit. For those reasons, we ask that the case be dismissed.
All right, counsel, this is your opportunity, of course, to respond in regard to this matter. And the statute obviously is quite clear and poignant as it relates to the commencement of action within 1 year of the occurrence or the notification of denial of benefits. And of course, on the other prong, that the providers essentially stand in the shoes of the underlying claimant as it relates to the deadlines, cutoffs, and notifications. You may proceed at this time, Mr. Green.
Thank you, Your Honor. Well, the statute, which is section 3145, sub 3, specifically says that a period of limitations that's applicable to the case is told from the date of a specific claim for payment of the benefits until the date the insurer formally denies the claim. So that's clear language there that talks about a specific claim for payment of benefits. Now, under the No Fault Act, insurance companies like to always say, well, it's derivative, it's this, that, or the other. That's not the case so much anymore. We have a right to proceed under section 3112, regardless of what happens with the with the underlying claimant. A specific claim for payment of benefits was made after the services were rendered in November of 2020. There is no evidence that the claim was ever denied, that specific claim. Now they're pointing to a letter from June of 2020, which is like 4 or 5 months before the services were rendered. And it's not a letter to my client, and it has nothing to do with my client's specific claim for payment, which is what the statute requires. So, and even if you look at the language of that letter, it says Comp 1 is unable to determine if Mr. Stromile is eligible for personal injury protection benefits from the city of Detroit without the above documents. We've requested this information on multiple occasions without any response. Therefore, your claim is denied. But that's not a denial of this specific claim. You know, Stromile didn't even have to make a claim. He doesn't have to in order for my client to make a claim, because they can do so under 3112. So that being the case, they've never specifically denied my client's claim. And frankly, I don't even see that as a full-on denial, because, all right, what happens if Mr. Stromile does comply? What if he does provide this stuff they were looking for? But realistically, that's several steps ahead of where we need to look, because again, the statute calls for a specific claim. Each claim for payment under the No Fault Act is a separate claim and must be proven individually. So if somebody has a surgery in October and has another surgery in September and another one in March, each one has to be specifically proven. Each one is its own separate claim. Really brief, this is a district court case. There are no, I'm sorry, go on.
I believe in Joe agreement screen and that assuming for the sake of arguments that the statements you made are accurate, that if that the claim that arises from the providers is predicated on there being some determination as to whether or not the claimant is entitled to benefits. I mean, the rights that the while the providers have a right to bring a direct lawsuit, those lawsuits are and claims are derivative, that they are in association with whether or not the underlying claimant is advancing or is eligible for benefits. And you raise an interesting query, and that query, of course, is it almost seems in this case that that the claimant not going forward to make a claim probably would have been more beneficial to your claim than the claimant's effort to go forward and then not operating in compliance. In other words, it almost like it works a little bit of a perverseness here, given that the claimant sought to advance claims and did not apparently participate properly or adequately in the process, and that resulted in some effort to deny the claim, some indication the claim is denied, and then your client subsequent to that time brings a claim, and this claimant has already been denied. So it seems to me that the denial of the claims or the denial of the claimant, if you will, and his claims has far-reaching effects, that it will affect the claims that have been existing and subsequent claims unless you can overcome that denial of the claimant. So speak to those issues, if you will, Mr. Green.
Thank you, Your Honor. And I think you raised a very good point there, because to a certain extent, if he had said, for example, I fraudulently procured the insurance policy, my client would be stuck with that. I would agree with that. But we are dealing with a statutory provision, and the motion here is limited to the 1 year back rule. Okay. And that specific section says that it is told from the date of a specific claim for payment of the benefits. And my client made a specific claim for the benefits, and the defendant in this case has yet to formally deny that claim. So really, that's where we are right now. The defenses that they're talking about, okay, that there is no coverage or anything like that, is a separate matter from the 1 year back rule. So, you know, just in general terms, a claim may be a garbage claim, but not because of the 1 year back rule.
Right.
Okay. So I just don't think summary disposition here is proper. And I suppose what would really probably seal the deal is if the defense can show that they sent something to my client after they submitted the bill saying, look, the claim is denied. If they had done that, if they had referenced at some point, yeah, we denied all of this stuff because he didn't cooperate back in June of 2020. That's the document that really starts the clock. And that's what they haven't produced.
All right, Mr. Ashton, it seems to me that in my read of this, that 3112, I believe, it seems to me that presupposes that there is not a pre-existing denial, if you will. Maybe I got that wrong. Go ahead, sir. Talk to Mr. Ashton.
Yeah, I think what we're talking about is the denial and the idea of a pre-existing denial. You know, what the act says is that a specific claim for benefits has to be denied. That letter was sent to the patient. It specifically says that your claim is denied. Any expenses that have been incurred will remain Mr. Stromiel's responsibility for payment. The plaintiff seems to suggest that after a claim is denied, that every single time that patient or any other provider submits any additional bills, every single one would have to be denied again, thus undermining the entire purpose of a denial in 3145, which just does not make any sense. Going back to where we started today, and as noted, you know, there was a recent amendment to the No Fault Act, which merely gave providers a right to file its own lawsuit. You'll note that no other amendments were made giving them other special standing or need for any additional notices of denials, etc. So it remains the law that the providers step into the shoes of these insureds or patients. And in this case, it's undenied, it's undisputed that a formal denial letter was sent to Mr. Stromiel denying his claim. Now, what happened subsequently was that Mr. Stromiel decided to continue treating. That's not something that can be held against the city because his claim was denied. If the provider wants to dispute this denial situation, what it needed to do was to file a timely lawsuit attacking a denial, but it didn't. It didn't take any efforts to pursue its bill for 14 months, which, separate from the tolling analysis, 3145 tells us causes its claim to fail because they did not take reasonable steps to pursue that claim.
All right, just one other question, Mr. Ashton. In your in the letter of denial, it seems that the letter specifically says that the claim is denied, and any benefits or any charges that you may have accrued that they are denied. It seems to look retrospectively rather than prospectively. What, if any, impact does that have on the implications of 3145?
Well, first, it does continue into the future, Your Honor. That's the entire purpose of an insurance carrier, or in this case, the city, issuing a denial letter to relieve itself of the duty to continue to provide PIP benefits into the future. Usually the argument that plaintiffs make is that any bills incurred before the denial have to be paid and the other ones don't. So in this case, it seems that it's convenient for the provider to kind of switch that around. But by definition, a denial is issued in order to, address liability for any bills that might come in the future. And that's the very reason why those letters are sent out. That's the reason why this letter was sent out. And unfortunately, Mr. Stramiel apparently did continue to treat. And if that's true, then this provider would have claims against Mr. Stramiel then, who decided to treat despite knowing that his claims had been denied, and therefore he would be responsible for those bills.
All right, I only take issue with you saying, unfortunately, Mr. Stramiel decided to continue to treat. I don't know if that was unfortunate or not.
Well, I probably misspoke. I suppose the assumption.
I just decided to point that out, which probably means that you did some things that were so flawless that I had to show something that was flawless. Mr. Green, and then the last word, Mr. Ashton. Mr. Green.
Your Honor, I just want to address one thing, and I think it's one of those things that one of the things that Mr. Ashton said is the whole purpose of sending out that notice is to give the notice, okay, is to let people know. And that's what the statute requires. Give notice of the specific claim, because what we're talking about here is something very mechanical. When X happens, the clock starts running. Okay, my client doesn't know that things were terminated. My client submits the bill, and the insurance company, who wants the benefit of the statute of limitations, is obligated to say, no, here's your explanation as to why we are not doing it. Once it's denied, now the clock starts. It's a very mechanical thing. And that's all they needed to do, and they haven't shown that they did it.
Last word, Mr. Ashton.
Last word, Your Honor, is that the city did do that. The injured party was notified that his claim was denied. All providers stand in the shoes of that patient. Therefore, those providers have notice. And as a practical purpose, when this letter was sent out in June of 2020, Mr. Stramiel hadn't even treated with this provider yet. So the suggestion is that somehow we're supposed to apparently notify, I guess, all of the providers of medical services in the state of Michigan who might provide services to Mr. Stramiel in the future. Clearly, that's not the standard. And let's not ignore the fact that when Mr. Stramiel, having received notice that his PIP claim had been denied, went to iHealth, all he had to do was to advise that provider before he received their services that his PIP claim had been denied, but apparently we're being told that he did not do that.
All right, the court has listened to the arguments on the motion for summary disposition in this matter. It sounds in the claim, the position taken by the city that is verified by the filing of the complaint with the court and by the accrual of the claim that the matter is brought before the court more than 1 year after the accrual of the claim. Also, the it's been pointed out by the motion that the claim had been denied and that there was no, effort to bring the denial to the court process for purposes of litigating that denial. So the denial remained in place at the time that the use of services occurred at the hands of Mr. Strohmeyer, who was the underlying claimant in this matter. Under the statutes that set forth herein, it does appear that the motion for summary disposition is well founded. The court's going to grant a motion finding that the benefits that accrued in this matter, secondary to services used by iHealth Pharmacy, are more than 1 year back beyond the date upon which the matter should have been brought to court. And moreover, that the denial that was issued to Mr. Stromel as a result of the city's response to his claim for benefits, that denial is effective in a global sense based upon the way that the statute is construed in this matter, and that therefore those services were denied retrospectively and prospectively, and that was not overcome by the pursuit of this matter in the context of bringing the matter before the court to litigate the issue of whether or not the claims denied were appropriate, and any action that was filed was more than 1 year beyond that time. For that reason, and for those reasons, the motion for summary disposition will be granted, and the court will sign an order consistent therewith. All right, thank you,
Your
John.
Honor.
Good day.
Thank you, Your Honor.
Back on the record regarding 9090, I should say, 27 Prism versus City of Detroit. I thought I saw the parties back on that. Maybe not. Is it that one? Well, no, that's something else. But I know what that is. All right. Mr. Noga. Oh, yeah, Ms. Mahone, that's what I'm looking for, the parties there.
Yes, sir.
Yes.
Right. And that would be the suffix 4776, that's for transport versus Nationwide. Believe I got
Yes,
that right.
we reached settlement on this.
I'm sorry.
We are settled.
All right.
We
All
are.
right, very so is somebody going to email me an order or something in this regard? Get that taken care of.
Yes, Your Honor.
Yes.
We'll have a stipulated order in.
All right. All right, very
Your
well.
Honor, I just wanted to check on with the substitution for Nationwide. You said that was signed and that's getting sent back out to us. I just want to make sure we have that.
Yeah, I was not here during that time, and so someone signed for me.
Okay.
So there is an order. You have not received a copy of that order?
Correct. I have not
Alright.
received it.
I have.
Oh, you have?
Alright.
Okay.
I will forward it to you.
All right, perfect. And you have the email address to send the order to here?
Is it still the Latifa email
That's
address? Okay, then I have that one.
All right, and you share it with Mr. Noga if he's whoever's going to do the order, so they make sure that they have that. All right. Thank you much. I wish you well.
All right. Thank you, Your Honor. You too.
I'll see you soon somewhere.
All right.
Okay.
Thank you, Your Honor.
I'm sitting this big one right here. Just
Okay.
out of the way. So wait for
Okay.
just one moment, everyone. I'll be right with you. right, this is case number 93114, strike that 93115-420. This is Rainmaker Recovery versus Ernestine Patterson. The matter is before the court on objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered in this case back in 2004. That judgment was renewed in 2014. The judgment is for $9,557.86. Subsequent to that time, various efforts have been made to collect upon this judgment. Thus is the writ of garnishment as it relates to the Chase bank account, and that is a matter that is before the court at this time. Your appearance for Rainmaker, please. Have anyone for Rainmaker Recovery Incorporated? All right, Ernestine Patterson, if you're on the Zoom, say something at this time. This Ernestine Patterson, if you're on the Zoom, please say something at this time. The matter set on for 10 o'clock a.m. Defendant petitioner indicated to the court that the funds or property are exempt or protected from garnishment. There's no further information provided on this objection to writ of garnishment. It appears that the petitioner has not appeared regarding this matter, and accordingly, the court will find that the objections are invalid, and the court will release any withheld funds to the plaintiff at this time. All right, the court is calling case number 18-146983. This is credit acceptance versus LaDeja Swan. The matter is before the court on the filing of objections to a writ of garnishment, together with a motion of petition for installment payments. The record should reflect regarding this matter that the judgment in this case was entered, well, it looks like it's been a while ago. I don't have a register of action, but it appears now that the objection to the writ of garnishment is in relationship to Stellatus, known as Chrysler Corporation, and that there is a petition for partial payments. Counsel, your appearance for credit acceptance, please.
Judge, may it please the court, I am attorney Richard Bruson. I am one of the attorneys for the plaintiff. I am the respondent to defendant's objection to a wage garnishment and also the defendant's motion for installment payment.
Thank you, counsel. Do I have last name Swan, LaDeja Swan, please?
Good morning, Your Honor. I am here.
All right, good morning to you, Ms. Swan. I've looked at your objections to the writ of garnishment. You indicated on your objections, at least you initially checked that you were under an installment payment. But you didn't, it seems that you scratched it out. I'm not sure what's going on there. And then you petitioned saying that you want to pay $20 a month on this judgment. Do you have any idea, ma'am, what the outstanding balance is on the judgment?
Yes, Your Honor. The remaining balance will be $7,734.84.
Okay. And Mr. Lucen, does your numbers comport with that balance, sir?
Judge, a few things to perfect the record. Initially, the record should note that the judgment entered in this case July 2, 2018. And then going forward, Judge, be quite honest with you, today I'm showing a judgment balance of $7,033.39, probably because the employer sent another payment to my office to reduce the balance. So I'm showing $7,033.39 And if I may go forward for another 45 seconds, just to conclude, defendant's petition is for $20 a month. I normally do not object to installment payment petitions, except if they will never pay the interest. The interest alone on the judgment is $76 per month. And so the $20 a month will never pay the judgment. Therefore, I cannot stipulate, and I would object to the entry of an order for that amount.
Yeah, I mean, quite frankly, I would never consciously, and I try to do everything I do consciously, I'd never grant a $20 a month installment payment on a outstanding balance of $7,000. Just that makes no sense. It's just incongruent with the objectives of trying to make some traction on getting the issue paid. I'll come back to that in a moment. Ma'am, why do you believe that the garnishment should not remain in place? It doesn't seem that you have any meaningful objection to it. Go ahead and talk to me, Ms. Swan.
Well, first of all, Your Honor, I've been dealing with this situation for quite some time now, and I just got a nice paying job. Right now, I'm a single mother of 2 children. I cannot afford to repeatedly have this amount taken out of my paycheck. I'm really not bringing in too much of anything, honestly.
All right, so how much is being garnished? You get paid every week, is that correct?
Yes.
And you've been hit with the garnishment several times. How much is garnished every week?
So out of each check, I know they're taking like at least 25%. So it's about like $100 and something out of each check.
Like, so that the 100 and something, is that 110, 125?
I want to say like, so let me see.
Just roughly, I mean, you know your money. Is it 195, 110?
Like 150.
Roughly, okay, got you. So, so under the garnishment, $600 a month is being, roughly is being taken, correct?
Yes.
Okay. So have you were paying under a partial payment order at one time, ma'am?
Yes, I was. And I couldn't afford it at the moment. I started going through a lot and I let it go. So
how much was that? How much was that per month?
I think it was $40 a month.
Oh, well, you want, that's what happens. You get off that the payment thing and you end up paying $600 a month.
I know.
I mean, that's, and right now I really don't see, I have to look for a particular category that it fits in order to stop that garnishment. And you really didn't have much here to work with in that regard. And then you bring the $20 a month thing, and I'm concerned about whether or not you're going to voluntarily pay. So that leads me to think that I maybe just leave the garnishment in place. And I know that's a hardship.
Well, no, I am going to pay it. I am going to pay it. I can't keep dealing with this, it's hindering me. So I'm going to pay it. I have no choice.
Mr. Rosa.
Judge, a few things, just to perfect the record. Defendant had a payment installment, I'm sorry, let me restart again. Defendant had an installment payment order in 2019. She could not make the payments timely. She fell into arrearage. The court issued an order in this case, setting aside that 2019 payment order on June 11th, 2019. Another thing I just want to say is that I'm showing that I've received 5 payments. They were in the amount of $138.85 from the employer, another payment of $99.74, a third payment of $53.01, a fourth payment of $72.54, and the fifth payment of $126.57. So the record was speaking in terms of round figures of about $600, that's been applied on this judgment. So that's what I have to say. I will stipulate to $100 a month. to avoid further garnishment. And I will further stipulate, if it will be available, to have that monthly installment payment begin 30 days from now. That would bring us to Friday, October 21. On that, I rest.
So do you, I guess my concern here is some type of wage assignment for the protection of both sides, because every time the payments are not made, then you're gonna end up in a garnishment situation. That's gonna take 25% per week.
Right.
So, so what I'm inclined to set that payment at $100 a month. That's exactly what I was thinking. And to set it up on a wage assignment. And that way, it keeps the money coming, and it also keeps Ms. Swan out of being in the situation where her garnishment could be as high as 600, maybe more than that. If you get a lot of hours in at the former Chrysler, then there's going to be a huge haul. There's always going to be 25% of whatever it is that you got coming in. And I think that it makes more sense to try to stick to some reasonable amount of paying it down, rather than occasionally ending up in a situation where you simply cannot take care of your other business because you've got $600, $700, $800 maybe coming out of your check by way of a court order. So I'm going to my finding is going to be on the objections to writ of garnishment. I'll find that the objections are invalid. I'll immediately release any withheld funds to the plaintiff. I will partially suspend the garnishment. And I will order that $100 be advanced to the plaintiff per month. And I suppose that would be a $25 a week garnishment. So I'm going to set the order up that way. And you take this order to your employer, they'll make the adjustment. Otherwise, you're in a situation where it's not, where it continues the way that it is. But I'm modifying the garnishment so that it will be $100 a month to be distributed at $25 per pay period.
Judge, just for the record perfected, the begin date for your order would be 30 days from now, Friday, October 21.
I'll go ahead and set it for October 21.
Thank you, Judge.
As the commencement date for this order.
Thank you, Judge.
All right, and ma'am, you'll receive a copy of 2 orders from me that effectuate this result, that will stop the garnishment or suspend it and amend it actually to the $100 per month, so that you get some relief in that regard. All right, I do wish you well.
Thank you, Your Honor. I have one question before we end this. So will the garnishments continue to come out my check, or will I be making them personally?
Well, I'm suspending the garnishment. As soon as you get this document from me, you want to take it to your payroll department so that once they see this document, they'll suspend the garnishment, and then they'll know to start taking out $25 a week beginning October 21st.
Okay, Your Honor. Thank you so much. Have a good day.
Thanks, Judge.
If you'll chat your email address, Ms. Swan, put it in the chat. I'll have my clerk to email to you so you could get it to your employer right away.
Okay.
All right, so put your email address in the chat.
Okay.
All right, thank you. Thank you.
Thank you.
I'm gonna make you finish up something.
Okay.
Yes. All All right, the court now calls case number 21-159-319. This is University of Michigan Credit Union versus, last name is Payne. That's, I'm gonna leave that to the defendant to tell me. All right, the matter is before the court on objections to a writ of garnishment. This relates to the Detroit Medical Center. Further relates to the entry of a judgment by default. That judgment was entered on the 7th of October 2021 for $10,852.41. I also have, strike that, counsel, your appearance at this time regarding University of Michigan, please.
Yes, Your Honor. Alex Thibodeau, P number 82939 for University of Michigan Credit Union.
All right, thank you, counsel, and good morning to you, sir.
Good morning, ma'am.
I'm looking now for Payne. The last name is Payne. Say that first name for me, please.
Yes, Centois Payne.
All right, thank you, Ms. Payne. And now that makes sense. Centois. All right, gotcha. All right, this is your objection, or these are your objections to the writ of garnishment. I looked at this in the garnishment form. You didn't check anything as the basis for your objections to the garnishment. So tell me, why do you believe that your payroll should not be garnished regarding this matter?
Well, I did some stupid stuff back in the day. I co-signed for my ex-boyfriend a car, and which he lied and said that he was paying a car note, and so now I'm to this. And like I work at Detroit Medical Center. I'm in the kitchen. I don't have much money. I have 3 kids. I was just trying to see if I could get on a payment plan just so I wouldn't get my check garnished.
So has your check been garnished already, ma'am?
No, it hasn't. Not
Okay,
yet.
nothing's been taken out yet.
When I came, the day that I came down there, when I went to the, she said that nothing has been taken out. I just got the letter because all my mail is forwarded to my dad's home. So I just really got the letter, so.
All right, ma'am. So what were you asking to pay on this per month, ma'am?
At least $50 each check, because I get paid every 2 weeks. So I'm saying like $100 a month.
All right, Mr. Thibodeau?
Your Honor, looking at this, this is, as far as I understand, the first time we've discussed a payment plan, unless those discussions have been had, with someone else. But I wasn't aware of such an offer. I'm not sure that 100 would be quite enough to cover or to make any significant progress on the outstanding debt, but perhaps 150 or 200 could potentially get us there if that was possible, Ms. Payne.
I guess the thing that council raises critical issues. One is that obviously the ideal situation is for the payment to somehow have some relevance to the amount of the judgment, so that subtraction occurs and it's actually getting paid down. The other thing the court does have to take into consideration is your ability to pay and your wage, how much money you make. You said you work in a cafeteria at the hospital. Is that correct?
Correct. I make $16 an hour.
I'm sorry.
Bi-weekly, yes. Yes, I get paid $16 and I get paid every 2 weeks bi-weekly, yes.
All right, you said you had 2 children, correct?
I have 3 children, 2 boys and a girl.
Yep. All right.
Yeah.
Any other source of income? Look like you froze up a little bit there, ma'am. Any other source of income?
No, I don't.
All right. And so first of all, as it relates to the objections to the writ of garnishment, clearly there is not any basis at law for the objection. So I'll find the objections invalid. If there are any funds that are withheld, I'll release them to the plaintiff. I will suspend the withholding in light of the oral request for a for a partial payment plan. So I'm stopping the garnishment or suspending the garnishment. And then I will allow for for a partial payment plan based upon your petition now. And the amount at $100 is not an insignificant amount given your level of income. And it does provide some payment towards what is a significant obligation here. So I'll go ahead and set the payment at that amount, and I'll commence that payment on October 21st. That's when your first payment under the order will be due. 10/21, you'll get a copy of that order for payment, and so you'll pay the $100 then, and then you'll pay it on that, which turns out to be the third Friday of each month. Understand, ma'am?
Yes.
All right, and counsel, you'll get a copy of the respective orders as well. And I do wish both sides well. Good day to you.
Absolutely. Thank you, Your Honor. Have a good day.
All right, this is case number. All right, this is case number 18-163-851. This is Credit Acceptance Corporation versus James Clark. The matter is before the court on the filing of objections to a writ of garnishment regarding the Michigan Department of Treasury, as well as a writ of garnishment regarding sloppy crab on East Jefferson. The record will reflect further that a judgment was entered in this matter by consent on the 12th of November, 2018. All right, your appearance at this time for the plaintiff, please.
Judge, may I please court? My name is Attorney Richard Gruson. My bond number is 35222. I am the attorney of, sorry for a minute. I am the attorney of record for the plaintiff. Actually, yes, I am. And then I'm also the respondent to defense objection to a income tax garnishment.
Thank you, counsel. And do I have Mr. James Clark on this Zoom, please?
Yes, sir. Good morning.
All right, good morning to you, Mr. Clark. Looking at your objections, you state on both forms that the amount is wrong.
Yes, sir. Yes.
Well, what are you talking about? You have a consent judgment that you agreed to back in 2018. What are you talking about? The amount is wrong.
The interest, I'm assuming that was $7,000, and now I get the letter that said $9,000, and I fall into a hardship. Now I can make payments in October to get this, going, the ball rolling again, because I fell under my house being took from me, and I'm trying to get back on my feet. So October the 21st, I can start making the payments back, and that's when I can generate more funds, and I don't want my money attacked. I just want to make the payment arrangement, if possible, Your Honor.
Yeah, well, they're coming for the money. Was there any garnishment yet? They take any of your money yet?
Not yet, sir.
Well, how much money are you making? Well, how much are you expecting at the Department of Treasury?
I owe taxes, so they won't get any of that.
All right. Well,
I'm behind on taxes, Your Honor.
All right, we know what to do with that one. What about sloppy crab down here in Jefferson?
Out of that income, I could do 150 a month for sure, if they'd accept it.
Mr. Wilson?
Judge, may I please court, at a $150 monthly installment payment, I will stipulate to that. I would gently suggest that the order be entered that will begin that $150 per month, 30 days from now, beginning Friday, October 21, if that is a convenient date for the defendant.
Yes, sir.
All right, that sounds like a reasonable way to approach this, and the other side is in agreement with this as well. I think that's a reasonable response. I will grant your oral petition for partial payment order at $150 per month. I'll set that on for commencement on the 21st of October, 2022. You will want to begin, you'll want to make that first payment, and then you'll want to make sure that you pay it by every third Friday of the month, because that's generally coming out to. You understand, sir?
Yes, Your Honor. Can the plaintiff send me information so I can send a money order to my address?
All he's got to do is mail it to my address, which is on the notice for the hearing today. I see that it was at P.O. Box 2305, Mount
Yes.
Clemens, Michigan, 48041.
I got it, sir.
All right, very well. As it relates to the objections to writs of garnishment, the Department of Treasury garnishment, both garnishment, the court will find that there's not a valid objection, and will release any funds withheld to the plaintiff. As it relates to the sloppy crab, I will suspend any garnishment there in light of the partial payment order.
Yes, sir.
All right.
What about the
Thank you,
taxes?
The taxes are released to the plaintiff. If there's any money coming, they would get that. If there's nothing coming, then that means there will be nothing.
Thank you, sir. Thank both parties.
Thank you, Judge.
Have a great day.
Likewise. This one is all set except. All right, this is case number 21-47204. This is second round subs versus L'Oreal Johnson. The matter is before the court calling of objections to a garnishment regarding Concentrix CVG Corporation. The record should reflect regarding this matter that a judgment was entered in this case by default on the 16th of September 2020 for $1,264. Subsequent actions have been taken in an effort to collect on the judgment. And then there is the writ of garnishment that brings the objection today. For the plaintiff's second round, your appearance at this time.
Good morning, Your Honor. Athena Augustinos, P63407 on behalf of second round sub.
All right, thank you, counsel, and good morning to you. I'm looking now for L'Oreal Johnson. If you're on the Zoom, please say something at this time. Ms. Johnson, or a person purportedly living on Rutherford Street in the city of Detroit. If you're here on the Zoom, please say something at this time. All right, the matter is set on for hearing at 10 a.m. regarding this matter. It looks like the petitioner has not appeared at this time. Council accordingly, the objections, which, by the way, on the objection form, the defendant did not, or petitioner did not indicate anything, or did not mark any box or anything regarding.
That's correct, Your Honor.
Any basis here. So I'm going to go ahead and find that the objections are invalid. And accordingly, the court will immediately release any funds withheld to the plaintiff and will allow the garnishment to continue accordingly. All right, thank you, counsel, and good day to you.
Thank you, Your Honor. You too.
That's that lady you already talked to.
Right, right. She has something up. I'm sorry.
Oh, yeah. They have their case in 524.